Hello, happy Friday. It is Friday and I am feeling this week, okay? We are getting into It Ends With Never. Yes, okay, there was a conference call today. I took extensive notes. It was an hour and a half. It was a lot, but we're going to go over that. Then we're going to go over some filings, a little bit of Taste Swizzy. We'll get there when we get there. And then also Stephanie motherfucking Jones and the dismissal that was granted in part and denied in part. We're going to dive right in. Grab your emotional support lip gloss. You are in frame with Mandy Magnan. I hope everyone's having the most amazing day. I was thinking about getting ready and like doing full hair and makeup and putting on this show today. And I just been so like not wanting to. I've been doing it all week, you know what I'm saying? I'm like in a chill mood. I'm going back and forth with my cast and my producers. Tomorrow we have a big screening. It's my film, my directorial debut called Desire is going to be playing at the Royal Cinema in Toronto at the Great Canadian Horror Film Festival. It's also a double banger of a day because the same film Desire has made it into a finalist at the National Independent Film Association, and it's a finalist in there tomorrow too. And then at the end of the month, it's going to be playing at another film festival. So Desire is like getting ready to go this month, and I'm just like in it. I'm trying to get a million things done at once, and yeah, but I'm here, okay? So y'all didn't come to hear me talk about that, but I just want to share some good news about the film. I'm super, super, super excited and kind of nervous to like watch it with a full theater of people and my peers and other independent filmmakers. But it is my directorial debut. It's a 15-minute running horror movie, so we'll see. Fingers crossed we get the Audience Choice Awards, and or at least it's just received well, because I always get so nervous when my butt is in that seat and all these people around and it's like me on the big screen. I don't know if that feeling will ever go away. It never has. But I just keep reminding myself that the film festivals that Desire is playing in and like being a finalist and it's being nominated and it's playing in like the Royal Cinema is like things that I used to wish for that other movies I played in would be in. Do you know what I mean? Like they would make it to those film festivals and they would play at that theater. And I just think it's so cool that tomorrow a film that I wrote, produced, I'm starring in, and I directed it is going to be playing there. Okay, that's it. That's all I want to say. So it's been a day, so I'm showing up like this. I do have my lip gloss on, okay, but other than that, we're just going for it. Let's get into the conference call today. Now, when I tell you I took notes on notes on notes, guys, look at all of this, okay? I'm going to spare you. I'm not going to go through all of the notes. I will say quickly that I think the lawyer for Jed Wallace, Mr. Babcock, amazing. He was a breath of fresh air that came on at the end of the talk, and I think him and Lyman are kind of on the same level. It sounds like they're both kind of like the same age bracket, so maybe that's why, but I thought that he was very well presented in court. I will say the audio didn't allow public hearing until after like 30 minutes, so if they did start on time, it did seem like they started around 2:12 instead of 2 o'clock, which is almost like the same time they started last time. It was usually about 15 minutes late. That's fine. They're busy. He's a judge. It is what it is. But the Judge Lyman did come on and ask everyone for their introductions. And then it just went to silence. It was very muffled, and then complete silence. And then after waiting for a long time, what I thought was really funny is a bunch of creators, I guess, and the people listening in the call like unmuted themselves, and everyone was like, hey, like, what's going on? What's happening? And I recognized for sure Katie. I think she goes by Katie Inc. or Katie NYC. I'm not really sure. Everyone knows Katie, from TikTok. She was on there and everyone was just kind of asking like, what's going on? We couldn't really figure it out. but then we just hung tight, and then about at 2:35 it kicked in and we got to hear it. So hopefully there will be a transcript. I know the judge told the counsel to request one because of that cutoff, as well as he did make some orders right there and then, judge's orders, okay? How it started when we came in was they were talking about the schedule on motion judgment and whether or not they were going to move for summary judgment, or whether they should move the deadline from the motion of pleadings to the summary judgment. Wayfair people are like, heck no, we shouldn't wait on our motion that we already submitted. We want the motion on the pleadings because we've already submitted that motion, and we don't want to wait until summary fact judgment because then it's so duplicative, it's this, it's that, and by that time you would have already dismissed, if not all, some of the filings, like some of the things that Blake Lively has tried to file. We want a ruling on the motion of pleadings, which is based just on law. Then Blake Lively's lawyer came in. It wasn't Ezra and it wasn't Michael Gottlieb. It was a man named Mr. Nathan. He came in and he was trying to say that they should move it and they should just do it all together, move the schedule, in order to be able to take in expert witnesses and have all of that inside of the motion for fact or for summary judgment. And what's really important here is because the motion on the pleadings that the Wayfair people filed is simply on the pleadings right now. They don't take in any discovery. They don't take in anything they took from the depositions. There's no expert testimony. There's no extra facts. It's basically just, does it fall under law? Does the law hold up to the motions and the pleadings that have been filed? Now, summary judgment comes later. This comes after discovery, and that's when you're able to put in depositions, documents, affidavits, and it's not just on the pleadings, but it actually looks at the evidence. So before they get to the summary judgment, Wayfair has filed a motion on the pleadings because they're saying, you need to look at all of these pleadings. It doesn't even fall under the law, so we're going to be doing all of this work and then do a summary judgment. And if you get us to do the summary judgment as well as the motion of pleadings, it's going to eat up more judicial time. It's kind of abuse in the courts. It's like there's no point to do it pretty much. So when Lively's people was like, no, we want the summary judgment. We want it all together so that we can include expert witnesses, the judge asked them, well, what would you include? Because sometimes, and most oftentimes, the experts that you bring in, oftentimes they don't really do much. So what kind of experts are you what are you looking for? Like, what are you bringing in that's so important to the case? Why do you want to wait till summary judgment? Because most of the time, if not all the time, the experts don't really lend a hand in this. Then Lively's people said that they're willing to bring in tons of experts. They want an HR expert, which was weird, PR expert, tons of digital media, causation, a ton, like six, she listed like six, like a bunch of experts that they're going to bring in. The Wayfair people said that they would like digital media people and PR. But before they even answered that question, the Lively people, Mr. Nathan, brought it back and says, it appears that it was overlooked at the fact discovery has been extended. Our idea is that it's quite possible that using but there's no guarantee, but it is possible that looking for ways to preserve it, they wanted to go back to the request to admit, and they said that was overlooked. They want an opportunity to use those requests to admittance, and they want that request to realign to serve request to admit with fact discovery. Then the judge asked if the Wayfair peoples have served any RAs on Blake Lively or vice versa, and they said no. But pretty much, yeah, it was just like everyone kind of going back and forth with the judge. I will say the judge was very snarky when it came to speaking to Kevin Fritz on the Wayfair side. There was a lot of times that he cut them off, and there was he was just a lot more strict with him than I found with Mr. Babcock, who is counsel for Jed Wallace, as well as Mr. Nathan, who is counsel for Lively. You could tell that, I don't think that he's on anyone's side, but he's definitely taking the position that Blake Lively here is 100% the victim, and you can tell that he's really holding his guns when it comes to speaking with the Wayfair counsel. He then went to Kevin Fritz and asked them to kind of explain why they don't want to wait for the motion on the pleadings and why he should kind of do it beforehand, which is like, yeah, we filed it, so like, why not? The judge was also kind of irritated that they waited so long, but anyway, Mr. Fritz really had some good answers. He basically said the motion on the judgment on pleadings attached Blake Lively's own allegations. You have several letters from Lively saying she may want to use experts or may want to do this in opposition to a 12C motion, which she can't do. Ms. Lively admits that she is a New York resident. All conduct happened in New York, and she goes through great lengths to tie in New York in her new allegations in her second amended complaint. There's no amendment that she can do at this point to completely change her complaint to oppose our motion on the pleadings. So he said there's no amendment, and she can't do just a 180 say, oh, wait a second, and flip now what she's saying was in New York to California. None of the evidence we've been exchanging in the last 8 months would change that. And then he goes on to bring up the retaliation, like there's no tie in the retaliation. There's no evidence that would change those allegations, and she's bound by them. The judge argued back and forth with him on that, saying that there's been cases where they have changed, a plaintiff has changed afterwards. And he said, no, I agree. Certainly a party has an opportunity to bolster or amplify her pleadings. You can't flatly change your pleadings. There is a 15-month difference, even in January. If you take the January 4th meeting, the all hands on meeting, and that's still 9 months later. There is no doubt that Blake Lively is saying that the retaliation took effect in August. Other judges and in your own very court have said that. So they're really fighting to get the motion on the pleadings dealt with immediately. Kevin Fritz goes on to say everything else is based on privilege, whether it applies or it doesn't. In respect to making these motions once or twice, whether the judge dismisses all 12 or 6 or 8, it makes it easier and significantly reduces the time spent on the summary judgment as well as at trial. Kevin Fritz did have a few clapbacks when it came to Blake Lively's counsel, saying that they have too much to do and that they shouldn't have to answer this because they're like in the middle of the end of depositions and discovery. And he said they have enough to do. That's not an argument. We had a lot to do and still answered. We want the same treatment you gave them. So during all of this stuff, we were knee deep in it. I'm paraphrasing at this point, but he was like, we want the same treatment. While we were always doing all of this, we had to answer all of this stuff. They were baseless arguments. Discovery was ongoing for a long time. We put the motion after her second amended complaint, and then she doubled down. These are all questions of law. The judge came back and said, is there prejudice to third parties? If I don't decide your motion on pleadings until summary judgment, why would I decide it before the summary judgment? Kevin Fritz came back and said, because we have to put together statements and depose non-parties. So if we're going to go on all of the claims, then yes, there's going to be so many more people that we're going to have to get affidavits from as well as talk to, because we were only allowed 20 people from each party to be deposed. So every single person was only allowed 20 witnesses to be deposed for each party. Therefore, we won't have to bother any of those third-party witnesses. The judge said, I should decide before November 5th. Fritz suggested maybe moving back the summary judgment deadline, but the judge is pretty hanging tight with these deadlines, it seems like, because he doesn't want anything to mess up trial. So he said, did you think before you filed this earlier to give us more time? Maybe I should submit this earlier. That's where I think the judge was being pretty snarky to Kevin Fritz and a little bit rude and belittling, in my opinion. Like, he went on a little bit of a tangent, just pretty much asking Kevin Fritz and the Wayfair Council, like, did you guys even think about this before you filed it? Like, did you say, maybe I should put this in earlier to give the judge more time and to give everyone time to reply? Like, did you guys even think of this? This is exactly what he said. Did you think before you filed this earlier to give us more time? Maybe I should submit this earlier. That's what he was going on about. Kevin Fritz said, "We put this together as fast as we could based on Blake's second amended complaint, which strengthened our motion for the pleadings." The judge said, "So only her second complaint did it? What arguments?" Fritz said, "She included a whole new section with Jed Wallace, the injuries in New York, a number of new paragraphs that ties the conduct to New York, and as we said, this is not late given other rulings in this court." The judge said, "I would not deny this motion as untimely either." So then they kind of found, finally after all of that, they found a little bit of middle ground. Kevin Fritz said, "We provided a remedy for the time, and I'm sure the judge and Lively has already looked at our motion, and we're confident that by summary judgment, there will be fewer claims going forward, and it will make everything much easier. The judge said, "Assume that I'm going to decide before any date that you got summary judgment. Even though you extended the date, why should I extend it?" Then again, the judge was going back and forth with Kevin Fritz saying, like, just because you extended it, why should I extend it? Tell me why. Like, why do you think that this should be extended? They were talking about expert discovery and whether or not it is a material fact. Again, Fritz was just like, this is the case management plan. The default practice is at least 14 days from completion. The parties and the court agreed at least 3 weeks in order to do it. The judge said, "What kind of experts do you want to bring in?" Fritz said, "Maybe there'll be experts on damages, PR, digital space, bots, something like that." The judge said, "Are you intending on using them?" Fritz said, "Certainly for damages, there may be an element we seek our relief on. Whether the expert weighs in on, I haven't put too much thought into it." Lively counsel comes back and says, "Not to doubt that you would give it to me, but would want to argue summary judgment. We contemplate experts, digital space, HR space, reputational harm, causation, and a few other things." Then they said, "Based on the summary judgment for expert discovery, we will make our own experts available before the deadline to the Wayfair parties." The judge said, "Fritz, are you requesting to get any kind of request admins in?" Fritz said, "There is a deadline for request admins and it's come and gone. No good cause for extension. They didn't ask, confident that for trial, we can solve this for authenticity on documents." He really wants the request for admins in because he said it makes it easier. Like the judge thinks it makes it easier and there is a consequence if they are misused. So he wants to hear arguments from both people. And then Kevin Fritz just agreed, like, "Look, we're not going to fight you on the request for admins. If you want them in, you want them in. However, we want them only for the authenticity of documents. We're not talking about other people, witnesses, If you want the RAs, it's only for the authenticity. Oh my God. It's only for the authenticity of documents." Then after that, there was not really any more arguments. The judge said, "Okay, the documents are to be used just for that, just for the documents." And then he said, "Are there any other arguments?" before he gives them over and before he makes his chance to set the opposition motion on pleadings the same date as summary judgment. Then Kevin Fritz came back on and said, "If there is not going to be a decision, it's going to be duplicating the briefing. If we have already addressed that, then there's no reason to do it again." He said like that, again, in the summary judgment. "If we address the proximity, we're duplicating and wasting judicial resources." Lively's people came on and said, "I think that setting the deadline to coexist inside summary judgment and motion pleadings makes good sense. There may be duplications, but that's our point. As an alternative, waiting a few weeks, they can raise their arguments of law, which we disagree, when they can raise them there." So they're saying, no, let's wait for summary judgment. Let's put it all together. Then Kevin Fritz came back and was kind of like, "Well, everyone's going to be filing a motion on the pleadings. And maybe we won't be filing, a summary judgment." And the judge kind of real quick snapped back and was like, "Knowing this case and knowing the way it's been going back and forth, I can't imagine you wouldn't be filing a summary judgment. Is there any other reason I wouldn't or shouldn't limit the RAs to only documents?" Then Lively's people was like, "No, that's the main reason. We want to get it done." So then the judge said he's going to grant the extension for RAs, the request to admit, to October 10th. And it is only limited to authentications of documents unless they both agree to other issues. So first they have to meet and confer and agree that other things are to be admitted. If not, it's only going to be to the authentication of documents. So then the Judge Lyman said that he was going to grant the extension to the Lively people for the request for admin, and he was going to do it for October 10th. And then he made some other rulings, and I don't know if he got the dates mixed up or not, but this is coming straight from Judge Lyman. I know there was a lot of people going back and forth on TikTok, like, did he mean October? Did he mean November? What is it? But this is exactly what he said. The request for an extension for summary judgment is denied. It is imperative to me that there are important issues raised, and I give you a decision before you go to trial. They're going to keep the November 15th date unless they can agree to November 12th, but there will be no extensions past November 12th that to resolve any issues for summary judgment before trial after that. The motion judgment on the pleadings was denied without prejudice. The Wayfarer have a right to make the motion, but he's setting the date to November 19th and the reply for November 26th. That's where I think he meant October, but we'll have to wait to see if the transcript comes out, because right now he says that is for November 19th, reply for November 26th. I think he meant October 19th to October 26th. He goes to the other lawyers. Stephanie Jones comes in, and I just wrote, shut up. It is as well, like, she get out of here. It's Stephanie motherfucking Jones. She had nothing to say pretty much. She just wanted to know if all the extensions, if what you're saying, if it's good for all of them, is it going to be for me too? And the judge was like, yeah, it'll be for you too. Like, whatever. Abel's lawyers come on. They had no objections, and Fritz was fine with it. That's when the Babcock lawyer for Jed Wallace came on, and he was quick with it. He's like, listen, as the court may recall, as defendants as first, they promptly moved for dismissal. The court ruled, which granted Lively to amend, which she barely did on time, 10 minutes before the deadline. Wallace filed a timely reply. We have come onto a deadline of October 24th where Wallace will have to pay, move, etc. if any claims survive against them. Mr. Wallace's deposition is at October 9th, and it will occur no matter what the judge agrees to. There will be a witness no matter what. Lively requested that, and we said, yeah, sure, we'll be there for you. It was funny. He just like is so dismissal of like Lively. It's kind of funny. They said we are in limbo, not the court's fault, not Wallace's fault, but they did not want to be invited to this party, but here we are. Texas case is still waiting. It was the first filed in this lawsuit in Texas, and they file a risk of not having enough time now if they wanted to, if they're able to stay in this case, to even counterclaim against Blake Lively. So Wallace would like to either relocate or extend his experts or the court filings motion to dismiss. He needs something done pretty much. Him and the judge kind of went back and forth. There was like a little bit of jokes between Lively's lawyers and Babcock where they were talking about the truth, and Babcock was like, yeah, well, there's many truths in this case. And then Lively's lawyer was like, I should have said substantial truth. And he's like, that would have been good. And it was just like a little bit of chuckles, like back and forth. But anyway, that was pretty much all that happened. It was just fighting, but pretty much Blake Lively got her extension past what she asked for. I think she got her extension to submit the request for admins. The Wayfarer people do get their motion on the pleadings heard by the judge, and the summary judgment is still going to be the summary judgment. So that's it. The judge said, I will try to get you some answers immediately. Okay, now, a lot of people are asking me about this whole Taylor Swift new album. Taylor Swift dropped it. I listened to it. Okay, it is what it is. I don't care whether any of the songs are about Blake Lively or not. I don't care about Taylor Swift. Like, her personal dynamics, what the songs are about, all the Easter eggs, if her and Blake are friends, if they're not friends, I don't care. I want to know when she hits that butt of hers in that chair, is she going to tell the truth? I want to see the text messages between her and Blake. I want the truth. Whether or not they're still friends behind the scenes, I've always said this. We don't know what happens behind closed doors. We don't know what these sources are saying. We don't know how much of it is fake PR, how much of it is lies, how much of it is just to continue to play the victim, which is what I believe Blake and Taylor are really good at doing. And she really ate this up, playing the victim all summer, all the way up until last week when she said there was somebody at Travis Kelce's house at 2 a.m. to serve her on behalf of Justin Baldoni. So they've been friends for over 10 years. She's the godmother to their children. And I definitely think that they're still friends. It's all a game. I only want the truth. She could write 500 million songs about Blake Lively, and I still wouldn't care. I want to know what happened with It Ends With Us and how much involvement she had destroying the lives of innocent people. That's all I care about when it comes to Taylor Swift and when it comes to her and Blake Lively's friendship. I think, and I've said this since the beginning, birds of a feather. That's all I'm going to say, okay? 10 years, after 10 years, you know who your friend is. You know what kind of person they are. You know what kind of girl they are, what kind of human being they are, where their morals at, who they are, who their husband is. Okay? Was she probably a little insulted that she was called a dragon? Maybe. Was she a little bit hurt that maybe she didn't know that Blake used her every chance she got? Maybe. But still, even then, I think she had a bigger hand in it than we've been led to think or believe. And I mean, yeah, that's all I'm going to say about that until I have actual information. Now let's get into this Stephanie motherfucking Jones filing today in the Abel versus Jones case. And then we are going to get to some of your comments from the week. This was a doozy. It's over 40 pages long, but the judge has come back and denied and granted some of the claims. Let's go through it. Okay, buckle in because this is a ride. So I did go over the entire thing. Like I said, it's over 40 pages. And I did find the background of it very interesting, but we all know at this point the background of everything that happened with Stephanie motherfucking Jones and Jennifer Abel. So just to save time, I'm just going to skip past some of the background because we all know what happened. I hope by now with, in this case of Stephanie Jones taking Jen Abel's phone and how she did it. Some things that are important to note is he does note that even though Jennifer Abel did have an Android when she started, she switched her phone over when she started with JonesWorks as long as it was agreed upon that Jennifer Abel could retain ownership of her phone number and keep it with her when she left JonesWorks. JonesWorks did not have a human resource department or dedicated HR personnel, but relied on business affairs personnel and Jones' various chiefs of staff to handle any personnel-related matters. JonesWorks also lacked written internal policies, including ones regarding the use of electronic devices and an employee handbook. He goes into the entire history of JonesWorks, how she had such successful clients, she was being represented, or she was representing Dwayne "The Rock" Johnson, Jeff Bezos, Lauren Sanchez, Venus Williams, Tom Brady, and Chris Hemsworth. When I was reading this, I was like, why is this important? But then he does go on to how everything was getting super toxic in JonesWorks, and in 2023, Dwayne dropped Jones after clashes between Jones and Johnson's team, and in the following months, JonesWorks was also dropped by Bezos, Sanchez, and others, and how that kind of started to spiral, and how the Business Insider was coming out with their article, and they were contacting former and current clients, and how, that just started Stephanie Jones on her whole spiraling and how things got really, really worse. It was interesting here where he said Abel was not responsible for the website or the article. On or about July 10th, 2024, Abel notified Jones of her plans to leave JonesWorks. She confirmed her decision on July 26, 2024, and communicated her intention to start her own business. Abel offered a 6-week transition period with an end date of August 23rd. And then they go into how for the 4 years that She was working for JonesWorks. Abel managed all of Wayfair's affairs, and that Abel was the point person on the account for Wayfair and Justin Baldoni, as Jones devoted her attention to clients she perceived as having higher prestige. In the summer of 2024, Baldoni and Wayfair were in the midst of a PR crisis involving tensions between Lively and Baldoni regarding the film It Ends With Us. Disputes arose between Abel and Jones regarding the management of the Wayfair Baldoni account, including regarding Abel's recommendation that Baldoni and Wayfair hire Nathan. In early August 2024, Jones inserted herself into the mix, seeking to box out Nathan and Abel. But after Jones contacted a reporter from the Daily Mail on August 8th about a story it had published regarding Baldoni and Lively, Wayfair instructed Jones to cease all activities on its behalf for the time being and to let Abel and another Los Angeles-based JonesWorks employee handle Baldoni's PR public relations crisis alongside Nathan. Wayfair and Baldoni expressed that they had lost all trust in Jones and that they just still only wanted Abel and Nathan to continue on their behalf. And then it goes into how on the final week, Jennifer Abel contacted the Chief of Staff, Gordon Duran, in order to make sure that her phone number was going to be released. And then on that infamous day, on August 21st, 2 days before her scheduled last day, Abel was led into a conference room at the JonesWorks office in Beverly Hills with Duran, a security guard, and extractions technical experts from Edgeworth Security, and an attorney affiliated with the law firm Frankfurt, Kernet, Kleen & Sells. The Edgeworth contractor then conducted a forensic search of her system that turned up nothing. Abel provided her passcode for the limited purpose of facilitating the transfer of her phone number after express confirmation from Duran and the JonesWorks attorney that they would release the phone number if she, as in Jennifer Abel, went straight to the Verizon store. Abel handed them the phone and was ushered out of the building. Abel's communications on her phone number showed that by the time of the film's premiere, she and other in Wayfair's circle held Lively in deep disdain. Yes, that's all it showed, in my opinion. With Abel's iPhone in hand, Jones and JonesWorks were able to access Abel's iCloud account and bypass the password protection that would otherwise bar their access to obtain her private communications. No later than August 21st, Jones allegedly disclosed to Lively, her husband Ryan Reynolds, and her public relations consultant Leslie Sloan private communications drawn largely from Abel's iCloud account, which were accessible through her confiscated iPhone. Shortly thereafter, Abel asserts that Jones took the further step of transmitting Abel's stolen communications directly to Sloan, Lively, and Reynolds. Abel alleges that Jones and JonesWorks provided the communications to Lively through what Abel characterizes as a sham lawsuit. Van Zam, baby! On September 27th, the Lively parties and their counsel filed a breach of contract lawsuit in New York State court on behalf of an inactive corporate entity alleging affiliated with Lively and Reynolds named Van Zan Inc. against several John Does. Once the lawsuit was filed, the Lively parties used it to issue a subpoena to JonesWorks for all data stored on Abel's phone, including private communications from her iCloud and email accounts, as well as potentially privileged information. Since there were no identifiable parties and no party had been served, the subpoenas were issued without notice, depriving Abel of any knowledge of the subpoena, much less the opportunity to object. The same day the lawsuit was filed, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer. Upon receipt of the subpoena on or about October 1st, 2024, Jones and JonesWorks surrendered the entire content of Abel's iPhone communications directly to Lively. Van Zan never requested the assignment of a judge, never substituted the Doe defendants for named parties, and never served the complaint on any other defendant. The only docket entries for the case are the complaint and the notice of dismissal filed on December 19th, the day before Lively filed her complaint against the Wayfair parties. Abel alleges that as a result, Jones and the Lively parties now possess the full contents of her iCloud and email accounts, including her photos, text messages, and emails. They say that Jennifer Abel's counterclaims include several causes of action: violation of the Computer Fraud and Abuse Act, violation of the Stored Communications Act, violation of the Federal Wiretap Act, violations of California Penal Code, invasion of privacy, false light conversion, intentional infliction of emotional distress, negligent infliction of emotional distress, and promissory fraud. A motion to dismiss a counterclaim is evaluated under the same standard as a motion to dismiss a complaint. On a motion to dismiss pursuant to Federal Rule of Civil Procedure 12b-6, a court must accept as true all factual allegations in the complaint and draw all plausible inferences from those allegations in favor of the plaintiff. And that got me thinking of who's the plaintiff in Wayfair and Lively. It just got me thinking about that and all of the things that he's kind of like granted, and the allegations are always kind of in favor of the plaintiff there, who is Lively. The ultimate question is whether a claim has factual plausibility. The plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. In evaluating Abel's counterclaims, the court is limited to the facts alleged in the pleading and any documents attached or incorporated by reference. Abel has not incorporated the Jones party's original complaint by reference in her counterclaims. Her counterclaims do not reference the original complaint, and to be incorporated by reference, the complaint must make a clear, definite, and substantial reference to the external documents. Although the counterclaims were filed in response to the Jones party's original complaint, that complaint is not properly considered on a motion to dismiss counterclaims. Wow, tough court here. The first one. The Computer Fraud and Abuse Act. Abel's first counterclaim asserts liability under the Computer Fraud and Abuse Act. To survive a motion to dismiss, the plaintiff must allege that the defendants intentionally accessed a protected computer without authorization, and as a result of such conduct, caused damage and loss. Abel alleges that during a 1-year period within the relevant time frame, her losses, including the loss of her privacy and reputational interest in and control over her personal data, the expenditure of funds to regain control over her accounts, and legal expenses arising directly from the CFAA violation exceeded $5,000 in aggregate. Those allegations are deficient. Damages defined in the statute as any impairment to the integrity or availability of data, program, a system, or information. And loss means any reasonable cost to any victim, including the cost of responding to an offense, conducting a damage assessment, and restoring the data, program, system, or information to its condition prior to the offense. Abel's only relevant allegation as to damages is that she expended funds to regain control over her accounts, but that claim is conclusory and merely parrots the statutory language of the CFAA. Abel alleges no facts about what those expenses were or when and how they were incurred. Abel's allegations do not state how the Jones party's conduct impaired or otherwise affected her computers, data, or files. Then he goes on to say that likely because of the deficiency in her pleadings, Abel has abandoned her CFAA claim in her brief in response to the motion to dismiss. Courts may and generally will deem a claim abandoned if a plaintiff fails to respond to a defendant's argument that the claim should be dismissed. Therefore, this is dismissed with prejudice. The Stored Communication Act, Abel's next federal cause of action from the Stored Communications Act as amended by the Electronic Communications Privacy Act, which was enacted to prevent hackers from obtaining, altering, or destroying certain stored electronics communications. It contains a civil cause of action against persons who gain unauthorized access to communications facilities and thereby access electronic communication stored incidents to their transmission. Jones argues that Abel's cause of action under the SCA must be dismissed because she only provides conclusory assertions that her messages were accessed while in electronic storage as required by the statute. Abel responds that her allegations that JonesWorks accessed her communications through cloud-based servers owned by Apple are sufficient. Jones and JonesWorks retained access to Abel's iCloud account for multiple months thereafter, monitoring and intercepting her private communications in real time. Whether or when cloud-based services such as iCloud qualify as electronic storage in the context of text messages is a novel question. The important distinction for the purpose of the SCA is between those communications that are stored or downloaded on a device which are not covered by the Act and those that are accessed while stored in a covered electronic storage facility which are. Thus, information that an internet provider stores to its servers or information stored with a telephone company if such information is stored temporarily pending delivery or for purposes of backup protection, are examples of protected electronic storage under the statutes. But information that an individual stores to his hard drive or cell phone is not in electronic storage under the statutes. Put differently, the alleged improper use of messages downloaded onto a device does not implicate the SCA because such messages are not in electronic storage within the meaning of the statute. But conversely, email stored on an electronic communication service provider systems after it has been delivered, as opposed to email stored on a personal computer, are stored communications subject to the SCA. Like, what is going on here? This is a very confusing thing of what is and what isn't, but he does break it down a little bit further, saying retaining emails while they are in storage on service provider systems rather than a company computer's memory triggers applicability of SCA. It is not self-evident that, as with emails that must be actively downloaded from a server, an iMessage received through access to the cloud is not immediately downloaded onto a device upon receipt. Even accepting that accessing messages from a cloud storage facility such as iCloud would be covered by the Act, Abel has not plausibly alleged that Jonesworks accessed her messages that way. Abel's relevant allegations are conclusory and do not make plausible the interference that the messages accessed were in electronic storage. She pleads that Jones was monitoring and intercepting her private communications in real time via iCloud, and that message produced to the lively parties were drawn largely from Abel's iCloud. But Abel references no messages or communications she believes to have obtained in that matter. Her own allegations support the contrary interference that Jonesworks access historical messages via the phone itself and not messages via the cloud. And because of that, and because Jones literally had her phone, she didn't prove well enough that Jones took anything that was in stored communications. So count 2 of the amended counterclaims is therefore dismissed without prejudice. So they can refile on that one. The Federal Wiretap Act. Abel also brings a claim under the Federal Wiretap Act as amended by the ECPA. The statute creates criminal sanctions and a civil cause of action against persons who intercept electronic communications. The key to liability under the Wiretap Act is the term intercept. The ECPA defines intercept as the rural or other acquisition of the contents of any wire, electronic, or oral communications through the use of any electronic, mechanical, or other device. Courts addressing the meaning of intercept narrowly define it to include only acquisitions of communications contemporaneously with transmissions, not storage. And while the Second Circuit has not addressed this issue, the reason for maintaining the narrow definition is sound, and this court adopts it. Jones moves to dismiss the claim on the basis that Abel has not alleged any interception as required by the statute, as she alleges that Jones viewed the messages after they were already in her accounts. Courts have held that the statutory scheme requires interception to occur while the communication is in flight. Abel responds that her allegations that Jones read the messages through iCloud in real time are sufficient to state a claim. She cites to Zeretzien, in which the court found that the auto-forwarding of emails received by a plaintiff's email account to a defendant's email account satisfied the narrow definition of intercept. Abel has alleged that Jones and Jonesworks monitored and intercepted her private communications in real time, but unlike email forwarding, Abel has not alleged that Jones or Jonesworks captured any messages before it reached its intended destination. Abel has not alleged that there was any point, whether on a service or on a server or elsewhere, that a duplicate was created for an original intended for a single destination, nor has Abel provided any factual allegations to lend plausibility to her claim that the messages were actually intercepted. Her only relevant allegation that the messages were monitored and intercepted in real time is conclusory and tracks the requirement of the statute itself. Without any plausible basis for the assertion that Jones was intercepting her messages, as the SCA narrowly defines that term, Abel's allegations do not cross the line from possible to plausible. Count 3 of Abel's counterclaims is dismissed without prejudice. State law claims. In exercising jurisdiction over Abel's state law claims, this court must determine which state law is to be applied. The Jones parties argue that Abel's second contractual choice of law provision controls and that New York law must be therefore applied. Here, the 2021 employment agreement states this agreement and the performer of the parties' obligation hereunder will be governed by and construed in accordance with the laws of the state of New York, without giving effect to any choice of law principles. That language applies only to the obligations hereunder and does not contemplate that the agreement covers the broader relationship between the parties, and so this narrow choice of law provision is not broad enough to reach tort claims incident to the contractual relationship or other non-contractual causes of action. Although that contractual provision does not apply, the courts nevertheless must determine whether New York or California law applies to Abel's claims. At least one conflict here is obvious. California recognizes invasion of privacy and false light claims, whereas New York does not. Given such conflict and the lack of any controlling contractual provision, in the absence of an applicable choice of law provision, New York has adopted an interest analysis which requires that the law of the jurisdiction having the greatest interest is the litigation being applied. They go on to say who argued what, and that Jones really never made an argument of whether the New York law should apply. And Abel did, and therefore this court will apply California law to the invasion of privacy and false light tort claims. As to the remaining tort claims, Abel argues that California law applies, and the Jones parties argue that the claim should be dismissed under either New York or California law. The court therefore applies California law not just to the invasion of privacy and false light claims, but to the remaining state law causes of action as well. The California Penal Code Section 502 imposes liability on whoever knowingly accesses and without permission uses any data, computer system, or computer network in order to wrongfully control or obtain money, property, or data. The section was designed to combat computer crime and hacking. Jones first argues that Abel has failed to state a claim because she has not alleged a scheme to artifice to defraud as required by the statute. That argument is without merit. The statute clarifies in Section 502 that liability is imposed for accessing data to either a device or execute any scheme or artifice to defraud or wrongfully control or obtain data. That Abel has not alleged a scheme to defraud says nothing about whether she has sufficiently alleged, as contemplated in Part B, whether the Jones party accessed her phone to wrongfully attain or control her data. The Jones parties argue that Abel's allegations under the California Penal Code must be dismissed because she has not alleged a sufficient connection to California. In support of their argument, they cite to Section 27 of the California Penal Code, which states that the code applies only to those who commit in whole or in part any crime within its state. Abel responds that she is a California resident, that the phone was seized and its data accessed in California, and therefore the acts occurred at least in part in California. It is true that, as the Jones party argue, the cited paragraphs do not specifically state that her phone data was accessed in California, but at the motion to dismiss stage, the court is required to make all reasonable interferences in the plaintiff's favor. It is a plausible interference from Abel's counterclaims that data on her phone was accessed without permission from California. Abel's allegations as to damages include that as a result of Jones's malicious scheme, Abel's life has been turned upside down, her career and reputation has been destroyed, her private information leaked, and her email box and social media page filled with a daily stream of death threats and abuse. As a direct result of Jones and Jones Works acts in violation of California Penal Code 502, Abel has suffered damages in an amount to be proven at trial. That is sufficient. Abel here has also more concretely alleged she has spent time restoring her phone number and iCloud information and investigating the unauthorized access. Abel has adequately alleged knowledge on behalf of the Jones parties that their access to her phone number was without permission. She alleges that she provided her passcode for only the limited purpose of facilitating the transfer of her number, and that afterward the Jones parties would access her phone only because they retained access to her iCloud without her permission. Furthermore, she alleges that because they had the iPhone in hand, the Jones party could bypass the password protection that would otherwise bar their access. Those allegations must be read together too in others in her counterclaim. For example, that using a personal phone at a public relations job is common practice and that JonesWorks had no policies that give it the right to monitor her phone, and that her willingness to port her personal phone number into her work phone was predicated on the reasonable expectation that she would retain sole and exclusive access to its contents and her private data and accounts. Abel had no reason to believe JonesWorks would attempt to access such data, or she would not have turned the device over without making prior arrangements to secure it. Despite lacking Abel's consent to access, review, or disseminate these communications, Jones and JonesWorks were able to do so. Taken all together, these allegations plausibly give rise to an entitlement to relief. The Jones party's motion to dismiss the fourth cause of action is therefore denied. Finally. Invasion of privacy. Abel next claims that JonesWorks and Jones violated her privacy by hacking into her personal communications without authorization. To state a claim for intrusion upon seclusion under the California common law, a plaintiff must plead 1. A defendant intentionally intruded into a place, conversation, no matter as to which the plaintiff has a reasonable expectation of privacy, and 2. The intrusion occurred in a manner highly offensive to a reasonable person. An invasion of privacy claim under California law is treated similarly and requires a plaintiff to show that they had 1. Legally protected privacy interest, and 2. Maintain a reasonable expectation of privacy, and 3. The intrusion is highly offensive. The Jones party argued that there can be no tort here because there was no reasonable expectation of privacy. Abel voluntarily ported her personal cell phone number into her work phone, which was a company-owned device. Although Abel consented to porting her phone number to and using the work phone, it is nevertheless plausible that employees in the public relations industry similarly situated to Abel objectively retain a privacy expectation in the content of a work phone. Jones and JonesWorks focus on the fact that Abel provided the phone and its passcode to JonesWorks upon her leaving. But again, she did so only under the alleged promise that they would use the passcode to release her phone number. According to her allegations, she did not at that point voluntarily surrender the personal data contained on her phone. She operated under the assurances of JonesWorks employees that they would uphold their agreement that upon her termination, her personal phone number would be returned even though the physical phone would remain. Duh. The Jones parties argue next that even if she had a reasonable expectation of privacy in her own work phone, the allegations as to the use of those messages are not sufficiently offensive. They must be highly offensive to a reasonable person and sufficiently serious and unwarranted as to constitute an egregious breach of social norms. Offensiveness is an indispensable part of the privacy analysis, as it reflects the reality that no community could function if every intrusion into the realm of private action gave rise to a viable claim. Abel has failed to state a claim. This is where I was like, what? She argues that the accessing, reading, and disseminating of her private communications and personal data for the purpose of humiliation and harm could be found by a jury to be highly offensive. However, she does not plead facts to support her conclusion. Abel alleges that at least some of the communications were shared with the lively parties, and that some messages were released pursuant to a sham subpoena. However, she does not allege facts to support the contents of the messages that were viewed or shared were private. Those messages are conversations with coworkers and clients that pertain to her PR work stored on her work phone. The most specific allegation Abel's complaint of this issue is paragraph 67, which includes a screenshot of a communication between Abel and a fellow employee. But the content of that message indicates that the Jones party shared with an employee what Abel had been saying to others about working with the employee. Abel's unsupported allegations that they were disseminated in the office is not alone sufficiently offensive. At base, Abel does not specify what information was accessed and read from her work phone. In the absence of such allegations, the court cannot infer that sharing went beyond what would be permissible under the circumstances in which the information was shared, and thus that the Jones party's intrusion would be highly offensive to a reasonable person. Well, I think I'm a pretty reasonable person, and I think it is highly offensive what Stephanie motherfucking Jones did to Abel, okay? Let me know if you agree. Abel also brings a false light invasion of privacy tort claim. False light is a species of invasion of privacy based on publicity that places a plaintiff before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. A false light claim, like libel, exposes a person to hatred, contempt, ridicule, or obloquy, and assumes the audience will recognize it as such. Abel argues in her brief responding to the motion to dismiss that the Jones party selectively disclosed her private communications to create a misleading impression of Abel's involvement in a supported smear campaign which Jones Works knew was false. However, her counterclaims contain no such allegations. The closest they come is in paragraph 93, in which Abel alleges that the messages revealed were modified with slicing, dicing, cherry-picking, massaging, and in some cases outright alteration. Absent any non-conclusory allegations as to the fault light claim cast on Abel, she cannot state a claim. Abel's fifth and sixth cause of action is therefore dismissed without prejudice. Conversion. For the seventh cause of action, Abel alleges that she had a possessory interest in her phone number, which she provided to Jones Works with the understanding that she would retain use of it and it would revert back to her upon her departure from the company. Abel continues that Jones and Jones Works committed the tort of conversion when they took possession of the phone number and refused to release it to Abel when she demanded its return upon her termination from Jones Works. The Jones parties argue that Abel had no cognizable ownership interest in the phone number that could give rise to a conversion claim, that she voluntarily transferred the phone number to a phone owned by Jones Works and to a Jones Works phone plan, and that she suffered no damages. The tort of conversion under California law involves the wrongful exercise of dominion over personal property of another. On the first of the three requirements to state a conversion claim, courts have only just begun to address whether a telephone number is something to which a possessory interest attaches. I mean, at this point, I think it should be already in there, like it's 2025, you feel me? They go into all of Jones's allegations that she said that, no, she owned the phone number. Abel gave it to me. That's it. That's all. We have it. No big deal. But he says, to that end, Abel has established also that she has a legitimate claim to exclusivity. Nowhere in their briefing to the Jones parties argue that while Abel's number was ported onto the company phone number, it could somehow be used by anyone other than Abel or was affiliated with anyone else other than Abel. A number of other courts have similarly determined that a telephone number is property that can be subjected to a conversion claim. That's really good to know. Then they go into all of the cases that Jones cited in her claim and in her counterclaim. But then he says, even if a telephone claim could qualify as a property right subject to a conversion claim, the Jones parties argue that Abel's claim nevertheless fails because she transferred the phone number to Jones Works voluntarily. That argument is inconsistent with the facts as pleaded. Abel alleges that she ported her personal phone number onto her work phone on the understanding that it would revert to her upon her departure. She made clear that upon her departure, she no longer consented to having her personal phone number ported to her work phone and requested that it be returned to her as soon as possible. Abel's porting of her personal number onto her work phone can thus be conceived as a bailment, which under California law is the deposit of personal property with another, usually for a particular purpose. And at that point, Jones Works retained that number in violation of that permission. It was a conversion of the bailment. If a bailee, having no authority to use the thing bailed, uses it, or having authority to use it in a particular way, uses it in a different way, unauthorized by the term of the bailment, or to a greater extent then authorized, such unauthorized use constitute a conversion of the chattel, rendering the bailee liable even for the loss of damage which his due care could not have prevented. Therefore, even though Abel did permit her phone number to be ported into the work phone number for a specific purpose, when that purpose was exceeded, the bailee in possession of the bailment is liable to his bailer for its conversion. Therefore, the motion to dismiss the seventh cause of action for conversion is therefore denied. Emotional distress claim. Abel's 8th and 9th causes of action are for the intentional and negligent infliction of emotional distress. To state a claim for the intentional infliction of emotional distress, Abel is required to allege that there has been 1. Extreme and outrageous conduct by the defendant with the intention of causing or reckless disregard of the probability of causing emotional distress, and 2. The plaintiff has suffered severe or extreme emotional distress, and 3. The defendant's outrageous conduct was the actual and approximate causation of the emotional distress. A defendant's conduct is outrageous when it is so extreme as to exceed all bounds of that usually tolerated in a civilized community. The Jones party argues that Abel has not met the high bar for emotional distress necessary to plead either its negligent or intentional infliction. Abel alleges that she was in panic and despair after Jones Works failed to release her telephone number. She alleges, too, that her life has been turned upside down and that she lives in fear of what is to come, given the vast troves of personal data in the possession of those hostile actors. Ooh, hostile actors, Ryan Reynolds and Blake Lively, okay. As a result, she alleges suffering extreme emotional distress and mental anguish. The allegations are not sufficient to state a claim. Jennifer Abel has been through hell because of Stephanie motherfucking Jones. Stephanie motherfucking Jones is the reason we're here. She's the number one monster in this whole entire case. I could never imagine what she went through. I've gone through my own toxic workplace environments. I've worked for nasty people. I can't believe, I think she has sufficiently pled her case for emotional distress, but okay. The test has an objective component. The emotional distress must be of such substantial quality or enduring quality that no reasonable person in civilized society should be expected to endure it. Here, Abel cites the revelation of messages concerning internal work relationships and her personal engagements with Jones Works clients. These are not far outside the realm of what might be expected in civilized society. As to messages with her fiancé, doctor, or legal counsel, Jones makes no plausible allegations that these messages were viewed by the parties internally or shared publicly. The alleged disclosure of those work messages is not sufficient under the exacting standard for emotional distress claims. Then he's saying it has to be feelings of fright, shock, nervousness, anxiety, horror, grief, mortification, humiliation, embarrassment, indignity, apprehension, fear, terror, and ordeal are not sufficient because they were not accompanied by further detail. So he just wants more. Give him more. I think she needs to just come out and pout everything. Lay it all on the line. Don't leave nothing. He does address the things that Abel is alleging that Jones Works did to her. I mean, it was pretty bad, the outrageous conduct from Jones Works to Jennifer Abel, okay, the way that and that she knows that from other people in Jones Works in the office that Stephanie Jones went around and shared her private messages with the entire office, mocking and disparaging her. She alleges that Jones Works monitored her communications and that she lives in fear knowing that they have access to that data. She further alleges that Jones humiliated Abel by announcing, per her psychic, that Abel would soon be pregnant with twins and that she referred to Abel as a 12-year-old drama queen. Finally, Abel alleges that it was only under duress that she signed documents given to her by the lawyers that would permit them to access her laptop. As discussed elsewhere in this opinion, Abel's allegations as to interception and monitoring are conclusory without any further elaboration on what was monitored by who or when, or what was intercepted by who or when. This court cannot draw the reasonable inference that the defendant is liable for the misconduct alleged. Abel's 8th and 9th causes of action are therefore dismissed without prejudice. Promissory fraud. Okay, we're almost there. Abel's 10th and final cause of action is for promissory fraud. Promissory fraud permits a plaintiff to state a cause of action in tort when a defendant fraudulently induces him to enter into a contract. As a subspecies of fraud and deceit, promissory fraud requires proof of 1. A promise made regarding a material fact without any intention of performing it. 2. The existence of the intent not to perform at the time the promise was made. 3. Intent to deceive or induce the promise to enter into a transaction. 4. Reasonable reliance by the promise. 5. Non-performance by the party making the promise. And 6. Resulting damages to the promise. The specificity requirements means a plaintiff must allege facts showing how, when, where, to whom, and by what means the fraud occurred. Abel's fraud claim is based on her allegations that JonesWorks induced her to hand over her company phone on August 21st on the promise that it would return her personal phone number to her. But JonesWorks breached that promise. She alleged that JonesWorks never intended to perform the promise when it was made, and that the company intended to and did dupe Abel into giving up the iPhone and passcode as to access, copy, and disseminate without authorization the private data stored on the device and information from accounts accessible from the device. The Jones party argues that Abel could not have been duped into returning the iPhone as it was a device owned by the company. That argument is a red herring. Abel here alleges just that JonesWorks never intended to perform the promise. Alone, the allegation would, for the reasons given above, likely be conclusory. However, also alleges that the promise was repudiated almost immediately after it was made. She states the JonesWorks gave express confirmation that it would release the phone number if she went straight to Verizon, but it did not do so, and after hours she left the store in panic and despair. California courts have found that such hasty repudiation of the promise or a failure to even attempt performance is the kind of circumstantial evidence that a court may rely on in making interferences in the plaintiff's favor. At least at the pleading stage, she has alleged enough to push from possible to plausible the interference that JonesWorks intended to repudiate the promise when making it. And Abel alleges the proximate cause of public disclosure of any messages that resulted in damages was the subpoena issued in conjunction with the alleged sham lawsuit. Abel's allegations do not permit the court to make a plausible inference that she suffered damages caused by the action she took in reliance on the defendant's misrepresentations. If JonesWorks was not going to return the phone number to Abel promptly, nothing about the promise that induced her to turn over the physical phone could change that. Abel would have been required to turn over the company-owned phone regardless. Thus, Abel would have suffered the alleged damage even in the absence of the fraudulent inducement, and no causation cannot be alleged, and a fraud case of action cannot be sustained. Plaintiff's 10th cause of action is currently denied without prejudice. The motion to dismiss is granted in part and denied in part. The Jones party's motion to dismiss the first cause of action is granted with prejudice. The motion to dismiss the second, third, fifth, sixth, eighth, ninth, and 10th causes of action is granted without prejudice. Abel has until October 31st to replead the dismissed causes of action, addressing the deficiencies elaborated in this opinion. And I hope she does. I hope she does. I hope she repleads everything. And if you're not following Jennifer Abel on Instagram, you should. She posts her stories all the time, and she posts like really good, like inspirational and motivational things. I wish Jennifer Abel nothing but the best. I hope they replead, and I hope they stay Stephanie motherfucking Jones down. I gotta admit, that was a pretty hard read for me. I don't know what's going on today, like with my reading skills or my dyslexia, but that was really hard, and I almost gave up. I started crying because I kept pronouncing words really wrong. So please forgive me if that wasn't the best reading of it. Okay, I don't know what's going on today, but it just happened the way it happened. Okay, and I'm trying to move on past it. But just a little bit of honesty is, yeah, that took me a lot longer. I think my brain is just a little kerfuffled. But yeah, halfway through, I was just broke down in tears because I really couldn't say anything right. I was mixing up all the words and all the syllables, and I was just what is going on? Please. Anyway, let me know what you think about all of that. I know that was a lot, but they do have most of them without prejudice, so they can refile. They have until October 30-something, 31st, 30th, 31st. Anyway, I just said it, so whatever the day was that I just said. But anyway, without any further ado, let's wrap this baby up and go over some of your comments from the week. Oh my gosh, I can't believe what just went over me there. That was a very emotional read. I was just so in my head. I just didn't know what was going on. I guess it's just one of those days, okay? One of those days, that's it. That's it. Here we go. Some of your comments in no particular order, just some comments that I found interesting from last Friday to today, okay? This is from KBKB. The book has a huge fan base too. They would have supported regardless. If anything, the fans didn't like even Blake. They really did not need Blake for this. Worst casting mistake ever. I completely agree. It was a very bad casting choice. And also there was online chatter and smear going on since the beginning, since casting, since the book was announced to be adapted into a movie. The fans and the book people, okay, the book readers, they were all over it. And they were very vocal when the casting announcement came out. At Blake's old nose. Wow, nice username. See, I can't even speak, guys. I don't know what's going on. Anyway, at Blake's old nose says, I'm not surprised, but even with everything, he's handling her on a silver platter. It won't be enough to save her ridiculously deficient case. All these filings are desperate and feel empty. I don't feel the same anxiety I used to because Justin is clearly pulling ahead. I completely agree. I have nothing else to say except I completely agree. I mean, yes, of course, the judge. I mean, he has to take Blake. First of all, she's the plaintiff and she's the victim in here, and it's about sexual harassment. So he has to make sure that he's making the calls that, like, at the end of the day, she can't come back and, and say anything. And I think right now they were playing chess and they have them. If it's not going to be the motion on the pleadings, it's going to be summary judgment, period. At Roses Wild 79 says, I think he is angry at her for both of them being in bad light this past year. This is about Ryan Reynolds. But they both chose not to be good, truthful people. I am surprised she would go to the media over it, though. That part seems like her PR team is trying to get her sympathy. I fully agree. This is when Blake was coming out saying how humiliated she was that Ryan Reynolds told a story about how he told her to F off. And it's like, was that whole story just planted to get Blake some sympathy points? Do I think her and Taylor play the same PR game in order to get sympathy and to always be victims? Yes. At Sigrinden7671, what Justin Baldoni say about Blake Lively is not an insult, it is stating the fact. But if you use Ryan Reynolds' proven point, Justin Baldoni just told what he was believing to be true. So there is nothing insulting at all. That's what I keep saying. Even if they amplified certain stories or, did whatever pro Justin and then amplified content about Blake Lively's past, those were all things that were true. He just believed them to be true because they were there. So I don't think any lies were told in this whole smear campaign. At Anemic Dramas Cop 6362 says, New York Times, Blake, Ryan Reynolds are outright lying, and yet they are still getting away with destroying Justin's reputation. I'm going to lose my mind if Justin doesn't get any justice. Well, we are here to make sure that he will always get justice. At least the people have him. At Just Snoopin says, you're right. You cannot use the G word. This is when I was talking about, but you cannot use the G word without it being removed. My comment's no longer on here. Anyways, thank you for using your platform to speak on Gaza. Thank you so much. Honestly, it's very, very scary times when you speak on anything, unless it has to do with entertainment, honestly. And I'm just really, really always grateful for all of you and all of your support and just the people in this community and on this YouTube, especially the inframers here. Like, I feel like we're all kind of aligned morally, and I'm just forever grateful for, all of your messages about that. And I feel like we all feel the exact same way, which is free Palestine. At amna.k1911 says, from the latest filings, it seems Blake Lively and the New York Times aren't aiming to win the case as much as to drain Justin Baldoni financially and end his career. I wouldn't be surprised if Ryan Reynolds pushed New York Times to file the latest suit. Justin Baldoni's already lost his podcast, the cast, and even the author of It Ends With Us against him. Plus, WME fired him and his upcoming projects are on hold, etc. This is their way of ensuring Justin Baldoni and Wayfair won't be able to recover in the industry. If, God forbid, Judge Lyman grants Blake Lively, New York Times their fee or sanctions, I wouldn't be surprised if Blake Lively then drops the case. The damage would already be done. Mic drop. Totally agree. At Valerie Woodard 9392 says, an actress that doesn't want to act, instead direct, costume produce, etc. A marketing company that can't market a film without upsetting and offending the likely viewers. A talent agency that tried to destroy its own client. A publicist more focused on smearing former clients and staff than promoting. And now a judge that cares nothing about justice to the point he doesn't even try to hide it. How did so many malignant narcissists manage to come together around a film with good intentions? I don't know, but when I figure it out, I'll share it with you. But yeah, I mean, yep. At MJR2379 said, just amazing that Josh Greenstein is the one who approved Blake's cut of It Ends With Us. Now, after working for Sony for 11 years, he supposedly left a few months ago. The other thing that will surprise no one, he worked with Ryan before on the movie Life in 2017, and who knows what else. I think allegedly Sony knew what was going on and possibly in on it. I also believe the Blake blackmailing Sony was just a cover story. Ooh, this is very interesting, and those depositions are going to be juicy. That's a good theory. I'm definitely going to keep that in here and clock it if I see anything, because yeah, it could be a whole cover story that they used so that Mr. Josh Greenstein and Sony didn't have to take any accountability or responsibility. And last but not least, I have Ikea Karose, and she wrote, I watched The Senior last Thursday. I'm planning on watching it again tomorrow. It really was a great movie, very inspiring and uplifting. Yes, if you haven't seen any of the Wayfarer movies, go out and see them. The Senior was an amazing movie. Okay, this was a long one, and my brain is scrambled and kerfuffled, and I don't want to talk anymore. I don't know what happened tonight, but I hope you got all the information that you needed. If any kind of Friday dumps happen, I will definitely be here tomorrow letting you know about all of that. And yeah, please drop all your comments, hype the video, like it, subscribe, all of that. It's free, y'all, to do, okay? So support a girl's channel. Anyway, I hope you have a great weekend. Again, if anything drops over the weekend, I will be here to let you know. I hope you have a great day, have a great night. I'm gonna go and rest and try to de-scramble my brain here because I feel a little bit not centered, and my readings just like proved it. Like something's not right. So I'm gonna go figure it out, and I'm just gonna rest and love myself and maybe do a little meditation and yeah, have a good time. So I will see you soon. I hope you're having a great Friday, and I love you. So I'll talk to you soon. Bye.